Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is Wednesday, July 28th. It's 11 a.m. Please join me in a moment of silence. Thank you. Let's take roll. President of the hearing room, we have Commissioners C. Williams, Belzer, and J. Williams. Joining us virtually, we have Commissioners Caston, Urban, Thomas, and Powers. Uh, Attorney Butler, please read the agenda.
Yes, sir. Good morning, Mr. Chairman, other members of the commission. First order of business would be to set the next commission business meeting. Staff would suggest Wednesday, August 4th, 2021 at 11 a.m.
All right, that will be the next date for the business meeting. You said August 4th, correct?
Yes, sir.
August 4th at 11 a.m. Thank you.
Thank you. Moving into the commission's utilities agenda, the first item on the agenda is for the commission consideration the interconnection agreement between West Carolina Rural Telephone Cooperative Incorporated and Teleport Communications America LLC.
Is there a motion?
Mr. Chairman,
Commissioner Thomas.
thank you. I move that the commission approve the interconnection agreement between West Carolina Rural Telephone Cooperative Incorporated and Teleport Communications America LLC.
Hearing Commissioner Thomas's motion, is there any discussion? Hearing none, we'll vote starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston. Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. Ayes have it. The motion carries.
Item number 2 on the utilities agenda is in docket number 2012-205C. There is a revised notice of transfer of control presented to the commission for information regarding Boomerang Wireless LLC, DBA In Touch Wireless.
Is there a motion?
Mr. Chairman,
Commissioner Powers.
thank you, Mr. Chairman. I would move that the commission accept the revised notice of transfer of control regarding Boomerang Wireless LLC, doing business as In Touch Wireless, as information.
Hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote starting with District 1. Commissioner Williams.
I vote aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston. Commissioner Caston. Commissioner Caston, how do you vote?
Let me mute this.
Would you say that one more time?
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 3 is docket number 2021-133-S. We have before the commission proposal for a name change, not pro-tunc, from Palmetto Utilities Incorporated.
Is there a motion?
Mr. Chairman,
Vice Chair Belzer.
I move the commission approve the application of Palmetto Utilities Incorporated for a name change, nunc pro tunc, to South Carolina Water Utilities, PUI Incorporated. So move.
Hearing Vice Chair Belzer's motion, is there any discovery? I'm sorry, is there any discussion? Hearing none, we'll vote. Starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Urban,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 4 are the three avoided cost dockets, docket number 2021-88E, 2021-89E, and 2021-90E. With regard to the prospective consultants interviewed by commissioners on Wednesday, July 21st, 2021, and a discussion regarding the selection of a consultant or consultants.
Mr. Chairman.
Commissioner Urban.
Mr. Chairman, we have one remaining contested avoided cost docket pending, which is docket number 2021-88-E, the Dominion Energy South Carolina Incorporated avoided cost docket. For the purposes of the Dominion docket, I move that the commission employ Power Advisory LLC as the commission's qualified independent third-party consultant to file a report on avoided costs in that docket pursuant to South Carolina Code Section 58-41-20. I further move that we authorize the clerk of the Public Service Commission to enter into negotiations with Power Advisory to serve as the commission's third-party independent expert. With regard to docket number 2021-88E, I move the commission adopt the following schedule for the Dominion docket. Rebuttal testimony will be due August 10, 2021. Rebuttal testimony will be due August 16, 2021, no later than 2 o'clock p.m. Eastern Standard Time. The hearing will begin on August the 18th, 2021, as previously scheduled. The consultant's independent third-party report will be filed on September 16, 2021. The discovery deadline for all parties, including the consultant's discovery deposition, must be completed by the parties before October 5, 2021. Consultant's testimony, which is subject to cross-examination and commissioner questions, would be scheduled for October 6 and October 7, 2021. We would then place the docket on the commission business agenda for our meeting on October the 13th, 2021. Proposed orders will be due October 27th, 2021. The goal of filing the commission's final order on November 12, 2021. As for the Duke Energy Carolinas LLC and Duke Energy Progress LLC docket, we received a filing on Friday, July the 23rd, 2021, which notified the commission that parties had entered into a proposed settlement agreement in the avoided cost dockets number 2021-89-E and 2021-90-E. The commission will hold a settlement hearing to determine whether this proposed settlement is fair, just, and reasonable and should be approved by the commission. I believe this settlement hearing is scheduled to begin Monday, August the 2nd, 2021 at 10 p.m. Since the parties and their attorneys have resolved all pending issues in dispute, there's no need for the commission to employ a third-party independent expert in the Duke Energy Carolinas and Duke Energy Progress dockets, which have been settled. Commissioners will have an opportunity next week to hear from all the settling parties and their experts. They ask them questions to determine whether the proposed settlement agreement is fair, just, and reasonable to all concerned, That's my motion, Mr. Chairman. Also moved.
Thank you, Commissioner Irvin. Hearing Commissioner Irvin's motion, is there any discussion? Fellow commissioners, there are a couple of things I'd like to address. I guess I'll take them one by one. Um, from what I understand from your motion, Commissioner Irvin, you do not believe that the commission needs to employ a third-party expert to provide uh, third-party objective opinions regarding the settlement.
Mr. Chairman, my reading of Act 62 and the section that relates to authorizing the commission in its discretion to hire independent third-party experts, uh, I think means that the General Assembly empowers us where appropriate, where we think it's appropriate and necessary to hire a third-party independent expert. In the Duke Carolinas and Duke Progress dockets, I don't believe it would be necessary or appropriate, given the fact that the parties have entered into a detailed settlement agreement and asked the commission to hear about it and approve it. There really is nothing in dispute. The Office of Regulatory Staff, of course, is charged by law to represent the public interest. And there are other interveners that represent their party's interest. And then there's the South Carolina Consumer Affairs Office that has the opportunity to represent the ratepayer interest. So I think that the common sense would dictate that why would we need an expert in the case that's been settled? First of all, under the existing statutory provisions, even if we hired an expert, we couldn't talk to the expert. Our staff couldn't talk to the expert. That expert could not talk with us or anyone else. So I just don't see the need for having to go through the cost and expense and delay of hiring an expert when one's not needed. That's my first, my thought. And the other thing is, you know, I'm not trying to decide who our expert should be necessarily. I chose to name it Power Advisory LLC in my motion because, as you recall, we used Power Advisory in 2019. And so they have a leg up, so to speak, on any other consultants because they're familiar with Act 62, they're familiar with our commission, and they're familiar with our process and procedures and rules. So if we hire another firm, and they're all well qualified, but if we hired another firm, they would have a learning curve to get up to speed. And of course, they're on their own because we can't consult with them. They can't ask us questions. We can't ask them questions. Our staff can't ask them anything. So I just wonder what the value would be of hiring an expert in a case that's already been resolved. The other point I'd like to make and call to your attention is that if we attempted to change any provision of the compromise settlement agreement, the parties retain the right and have the right to withdraw. And if that occurs, we'd have to have a full-blown hearing in the event that occurred. So for all those reasons, I just think common sense dictates that we have a Dominion contested docket. We can hire an expert. And by the way, I think that the presentation by London Economics was a good presentation. If the commissioners want to consider other of the four that were selected, I don't believe Dominion even filed any comments about any of the consultants that we interviewed. So they didn't timely file any objection, so I think we're free to hire any of them. But the reason I chose Power Advisory is we've worked with them before, they're familiar with our process, and I think they could hit the ground running, and we wouldn't lose time because we do have a statutory deadline in November to decide this case. Thanks, sir.
Commissioner Urban, thank you for sharing your position on why you believe the commission should not hire an expert. I have a different position that I would like to offer to the commission. When you read 584120, paragraph A, the last sentence says, any decision by the commission shall be just and reasonable to the ratepayers of the electric utility in the public interest, consistent with PURPA and Federal Energy Regulatory Commission's implementing regulations and orders, and non-discriminatory to small power producers, and shall strive to reduce the risk placed on the using and consuming public. And so when I read any decision, that includes the hearing on the merits, obviously, but it also includes the settlement, approving the settlement. And hearing your position, it almost comes across as the settlement is a done deal. And I just don't see it that way. While the parties, some of the parties, and I should add, may have agreed to terms, it's the commission's responsibility to determine whether or not those terms meet the requirements of the paragraph I just read. And with the General Assembly giving the commission the authority to employ an expert to help us reach that goal, I take the opposite position in that it doesn't make common sense not to do that. The money has been appropriated. The time has been scheduled. And if the settlement is what you believe it is and what the parties believe it is, I'm sure it should withstand any scrutiny that is given by the third-party expert. I think that the commission should be cautious not to use a tool in the toolbox that was given to us to make sure that we, among other things, reduce the risk placed on the using and consuming public, that we ensure that all of our decisions are just and reasonable to the ratepayers of the electric utility. And an expert will only aid in that effort, not take away from it. I think it's also important to note that this settlement does not include the signatures of all interveners. Unless something changed since the start of this hearing, Johnson Development Associates is not a signatory. Neither is the Office of Consumer Affairs. And again, even if they were, the commission still bears the burden to ensure that the settlement is appropriate, to put it shortly. Now again, we all, the 7 of us, represent 7 congressional districts, and we all may have different opinions on this. I'm just sharing mine, and it's definitely not out of disrespect. It's just out of being transparent that I believe if we do not hire an expert in a case that's as important as avoided costs, even to offer an objective third-party review of the settlement, we are not doing all that we can do, all that's in our power to ensure that the best possible outcome is reached. And I would even say that, you know, for me, I have no need to discuss the case with the expert. There's been discussion as to whether or not the commission should have the authority to discuss the case with the expert, direct the expert, have the expert essentially work for the commission as a personal expert. I don't think that's necessary. I think it serves the public interest and it's more transparent if the third-party objective expert does not communicate with the commission, and only works for themselves in an effort to ensure that the settlement is just and reasonable to the ratepayers of the electric utility and the public interest consistent with purpose and so forth and so on. That expert would be cross-examined if the party so desired by the parties, and the commission would also have an opportunity to ask questions. And considering the 600,000 plus, 700,000 plus payers that make up the territories of the Duke companies, I would have a hard time explaining to that ratepayer, and you know the ones we've seen that come and really don't have a great detailed understanding of what we do here. But I think they would understand that we had the opportunity to hire an expert, but we didn't. I would have a hard time explaining why when we have the time and the resources to do so. For those reasons, I would have to respectfully vote against your motion.
Chairman Williams.
Commissioner Caston.
Um, I've considered, I guess, the arguments on both sides, and I think they all have merit. That said, as I've thought more deeply about this, you know, I don't think we need to hire a consultant to review the stipulation at this time, for a few reasons. One, while I can't speak to the past, but I can speak to now, and what I hope I would like to see the shape of the future to be. That as a whole, the commission has generally encouraged parties to come together to try to work out differences and come to an agreement. I believe this commission has been successful in that some parties and utilities have done that, which I think is a good thing. Doesn't mean that it's perfect, but at least they've worked toward building a consensus or coming to agreements. My general sense is that we have the stipulation that we can review and the information that's referenced. And if upon doing that, and after asking questions or at the hearing next week, if the commission does not feel comfortable with the stipulation or approve the stipulation, then we could move to hire a consultant. That's my general sense at this point in time. Understanding and respecting, the concerns you have and the thoughts you have at this point in time, I don't think we need to hire a consultant to review the stipulation at this time, but that's just my opinion and mine alone.
Commissioner Caston, I definitely respect your opinion. While I definitely understand Commissioner Irvin's rationale, I don't agree with it, but I understand where he's coming from. With not hiring an expert, I'm not sure I completely understand not hiring an expert at this time. But then, if we have, I guess, questions or issues with the stipulation, then hiring an expert, that comes across to me as trying to fix your car yourself. You can't do it, so you take it to a mechanic who can. Usually that just complicates things even more in my previous experience. I think if this commission feels that we don't need the assistance of an expert, we feel like we're more than capable and competent to fulfill the statutory requirements, despite the fact that the General Assembly gave us the opportunity to hire expert and funding to do the same. If that's the way the commission votes, that's on the commission. I'm just one commissioner. I just don't think it's wise to do so with the stakes so high and the opportunity exists for us to do so. at least I haven't heard any reason or rationale that I understand up to this point. But again, I respect all my fellow commissioners, and I respect your position. I just disagree.
Mr. Chairman,
Commissioner Urban?
I'd like to respond to one thing that you noted in your comments. You mentioned one of the parties to the Duke dockets, what it calls dockets, Johnson Development Associates Incorporated. They did file a letter serving all parties on July the 27th, 2021. Their counsel of record, Weston Adams III, with Nelson Mullins attorneys, informed Ms. Boyd that, and I'll just quote, as you know, I and my firm represent Johnson Development Associates Incorporated, in the subject proceedings. We're in receipt of and received the stipulation of agreement dated July 23rd, 2021. In parentheses, the stipulation filed in both dockets. Subject to the Commission's approval of the stipulation, JDA does not intend to submit testimony, evidence, or argument in these matters, and accordingly would not need to schedule hearings. JDA, however, reserves the right to have the matters decided at a hearing and submit evidence should the circumstances change. JDA appreciates the Commission's consideration of this matter. Please contact me for any reason if I can be of further help. So JDA has informed us that they have reviewed the stipulation and have no problems with it. So again, they may not be a signatory to the agreement, but they have no objection. So I just wanted to place that in the record so there'd be no misunderstanding about what JDA's position was. Thank you.
Mr. Chair.
Is that Commissioner Powers?
Commissioner Powers, yes, sir.
Sir, go ahead, sir.
Thank you very much. Like Commissioner Caston, I think I have floundered both ways on this issue. And it seems to me that at this point that I'm concerned that although there is a stipulation, the consumer advocate has not been involved. Is that correct?
That's correct.
That's correct. Per my understanding, Commissioner Powers.
Which has me leaning back toward, getting whatever help we can get. I think the commercial says, the more you know, the more you know. And it kind of makes me think that way. I certainly feel both positions are right, except that we have to choose one or the other. And I just feel now that I've heard some of the comments that it may be my vote to hire an expert. I think if we hire an expert for one case, we certainly have to hire the expert for both. And I don't know that that language is contained in any sort of proposed motion or needs to be in some proposed motion. Thank you.
Mr. Chairman.
Mr. Chairman, if we choose to hire an independent expert, won't that delay the hearing next week? Because I don't know, now that the parties have settled, I'm not even sure that they have they already released their expert witnesses? Do they even expect, to go forward with the case? It throws a monkey wrench into our schedule, and we run the risk of not meeting our statutory deadline. I just ask the commissioners to give that some thought, because it may take some time to get an expert on board, get them up to speed. We certainly want them to be available at the hearing to listen to the proceedings, either in person or by video. So we need to think through this carefully, because the hearing's set for 10 a.m. on Monday morning. August, I believe that's August the 2nd, isn't it? Yes, sir.
Yes, sir, it is.
So how are we gonna logistically handle that?
Well, I think to answer your question, Commissioner Urban, I think the experts or the consultants, whatever you want to call them, the bidders, the parties that we interviewed last week were well aware that the hearing was scheduled to start on Monday, whether that would be a settlement conference, my term, I use that term, settlement conference, or a hearing on the merits. I think if we decided to hire an expert today, Ms. Boyd, Executive Director Boyd, with the commissioner's input, would set the parameters for the contract and set the parameters for what we would expect the expert to do for the settlement, to review the settlement. And just thinking off the top of my head, that would be to review all the filings, including what's currently filed in the docket and whatever settlement testimony they file, review the settlement hearing, which, you know, shouldn't take any more than a day or two, have the same amount of time to prepare their report, render the report, put it on DMS, allow the parties to review it, allow the commissioners to review it, and then bring the expert back to be subject to cross-examination and questions from the commissioners if there are any. I think the process is as simple as that. Quite frankly, I think it will be even easier since the parties have agreed to waive their rights on certain issues, and the only cross-examination would be the parties' cross-examination of the expert witness based on their report.
What rights have the parties waived, Mr. Chairman?
Cross-examination.
I don't believe that's the case. They have to proceed with the understanding that our hired or engaged expert may come out with a decision that's contrary to the stipulated settlement agreement. If that's the case, they need a complete record. I'm not sure the parties are ready to present a complete hearing transcript. But if I were representing one of the parties, I would want everything in the record.
Well, the parties have been well aware of this process and followed it along. None of the parties, to my knowledge, have objected to our hiring an expert in the Duke cases, even though they submit the stipulation. I think Duke's lawyer did, in a footnote, make the comment that the commission is not mandated to hire an expert, but it was within the commission's discretion to do so. So I think that I just don't see it that way. I think that the parties would be able to still protect their rights if the settlement does not hold up. I think they even say that in the settlement agreement.
Well, you're assuming a lot. You're assuming that I would think that these are parties and their experts maybe have made other plans. These experts may be committed to other proceedings already. We can't just assume they're all available and ready to present the case on the merits Monday morning at 10 o'clock. I think we're opening up some potential scheduling difficulties. That's just my opinion, but I'll give my other colleagues a chance to weigh in.
I understand, Commissioner Urban. Well, the hearing is noticed for Monday morning at 10 a.m., and I don't know how long that notice has been there. And the same risk, in my opinion, that the parties face with the expert is the same risk as they face without the expert, because, again, the settlement has not been approved. Unless you know something that I don't know, there's no guarantee that the commission is going to approve the settlement. And so let's just say that we don't approve the settlement. They face the same fate as they would with the expert or without. Commissioner Williams?
Chairman, thank you, Chairman Williams. I want to go back to Commissioner Caston's proposal and just ask the question of more experienced commissioners as well as staff. what would the idea of carrying this over and losing 1 week due to our schedule, if I understood Commissioner Caston's suggestion, which was that we have the settlement hearing, as I think you called it, Chairman Williams, and make the decision about the hiring of the experts based on that information. I know we're already on a tight time frame, so
Are you asking me, Commissioner Williams?
I'm asking any fellow commissioners and Director Boyd.
Mr. Chairman,
Vice Chair Belzer?
I'm in favor of hiring an expert for both dockets. And I would say that going forward, it would be, if the commission chooses to hire an expert for the two Duke cases, it would behoove us to go ahead and do so that the contract terms could be worked out, and the expert would be available to listen in on the live hearings. Begin with reviewing the testimony, the settlement, whatever they need to review, but be available and watching the hearings that go forward next week. I think it would be better for them to go ahead and get started and not lose a week and then have to view a video. That's my opinion. I do have some other comments, but in response to Commissioner Williams, and I'm not sure if she's through, that's just the point that I want to make on that. And I'll come back to my other comments if she's finished.
Chairman Williams.
Commissioner Caston?
As I said initially, I think there are excellent points and arguments on both sides. What caused me to kind of coalesce more around where I came to, actually late this morning, was as I thought about other cases that we have pending or before us, and in the past, that again, the hope or desire was that parties would work together to come to some conclusion or decision, not meaning that we had to accept it, but that was the hope and desire that would occur. So if I believe the commission has the ability, individually as commissioners and with staff, to evaluate the information set before us now. Now, if we think we don't have the staff we need or the adequate staff or whatever, then that's a separate issue and something we should resolve or take care of. But I believe, based on the information we have, the question before us would be, okay, do we agree with this or not? If we do not, then what additional information or expertise do we need beyond what we have? Because if we do this on this one, why would we not do it on any other stipulation that's set before us? And that's a rhetorical question. You don't have to answer it unless you choose to. So again, I understand both sides, and don't, I think excellent arguments, both sides. But this is why I am where I am. And I think we have what we need to at least evaluate what's before us now. And at the hearing next week, decide based on information we receive, questions we ask, and the information we currently have, do you feel good with it or not? I think that question should be asked and answered before we go to the next step, but that's my opinion. And should we pursue or follow Commissioner Irvin's motion? Actually, I would prefer maybe that we modify the motion some to decide if that is the consultant we want to put in it. I think they were all excellent, but I would probably prefer we go another route. That said, that is really where I am and why I'm there. Is this stipulation any different than any others that we have had, at least in my tenure, or others that may come? Um, that's all I had right now.
What I would say to that, Commissioner Caston, thank you for your comments, is that uh, because of the avoided cost docket, we are afforded, my understanding at least, is because this is an avoided cost docket, we were empowered to hire an expert to assist us in performing our duties. I don't think that power necessarily exists in any and all cases before the commission. Um, Further, for me, it's not a question of whether or not uh, our staff is every slot that's available in our staff is full, as much as it is employing the services of a third party objective uh, professional to review the information before the commission that has no connection to the commission other than we facilitated interviews that everyone could take part of, and other than we control the contract terms to fit the scope of work that we want them to perform, and other than the commission paying for the expert. Um, but this, please make no mistake about it. While this expert is employed by the commission, the expert works for the truth based on how they see it. They have no political motives or political gains. They have no financial gains or business gain other than completing the terms of the contract. It's a completely neutral party that's giving a position. To me, that increases or has the opportunity to increase public trust and transparency. Because I'll tell you this, well, let's just say, I hope it's not the case, because I don't, if the parties feel like the settlement is a good settlement and um, we vetted and we feel the same way, that's great. But what if there's something there that we don't know? And what if there's something there that expert brings out? That if we would know, if we knew it, it would change our position on the settlement. Would the public not want to know that? Would the ratepayers that are captive in DEP's and DEC's market, that depend on the commission to serve as the market, to serve as that final decision maker, would that ratepayer not want to know if there's some information that the commission may want to think about before they approve or deny the settlement? I think they would. So we could be staffed to 200%, and I still think that there would be a place for the expert. But again, that's just my humble opinion. Hopefully that answers your questions.
Um, can you hear me? Okay, Chair.
Yes, sir.
Good points. And I understand the I guess distinction between the avoided cost and the regulation or the statute. I guess in terms of where it is now, where we are now relative to the parties agreeing to something and simply looking for our, I guess, endorsement. Now, whether we endorse it or not is entirely up to the commission. Again, I don't I'm being repetitive, and I don't need to do that or delay it or prolong it any. I would uh, I would desire if Commissioner Irvin would, I guess, modify the motion in some way that if this would be acceptable, that perhaps we, I guess, notify or at least identify a consultant for the Duke and or Dominion uh, cases if needed, should after the hearing, the commission not approve the stipulation. But not uh, use the consultant for the stipulation, if that makes sense. That was poorly worded.
I think you're just asking Commissioner Irvin to make a friendly or accept the friendly amendment to
Yes, I'm sorry.
replace.
I meant that to Commissioner Irvin, not Chairman Williams.
Right. So I think the
Well,
question.
I'm certainly open, Mr. Chairman, excuse me, I'm open to suggestions as to how to improve the motion, but I'm going to predict that the parties are going to be in shock to learn that they're up on our hearing docket Monday morning to present a full-blown hearing on the avoided cost docket for Duke Energy Carolinas and Duke Energy Progress. I think the parties and the attorneys thought this thing was over. They entered into an agreement. If they want to come and explain it, we would appreciate that, because we ultimately will, as commissioners, have to decide whether or not to approve it. But I think it's unfair to the parties and the attorneys to hire an expert when that was not anticipated. As the chairman pointed out, Duke Energy noted in their letter to the commission in footnote 2 that they didn't think an expert was needed. And nor has, in fact, no one's asked us to hire an expert. ORS hasn't. Consumer Affairs has not. Consumer Affairs has seen the stipulated settlement, and they filed no objection. So as far as we know, everybody's in agreement. Let's hear what the parties have to say next week. And then if we're confused or we think that somebody's hiding something from the commission or the public, we can always decide then we want an expert. But I think it's a mistake to do it now, because the parties have all told us they've checked out and they've checked off all the boxes and said, we're aware of it. We're asking the commission to approve it. And it's our job. We're the ultimate experts. And that's why the PERC committee requires us to take an exam before we can even run. We have to pass a written essay examination about avoided costs and about rate increases. And so we ultimately are the experts. And bringing in somebody at the last minute from out of state, honestly, what good is that going to do? Is it cover that we need? I don't need cover for my decisions. I'm going to listen to all the testimony and evidence and make a decision. I just think it's a waste of time and money, and it's going to blow up a schedule. I think you're going to hear from the parties this afternoon if we go the route of an expert, because they're not anticipating that. They don't expect it. And what other choice will they have but to give us a full-blown hearing? It won't be a settlement hearing. They'll have to present everything. And not knowing whether we're going to ultimately approve it, because the expert's not going to weigh in until, for a couple of months. The expert's going to be subject to all their discovery requests, all their requests for admissions, answers to interrogatories. Then it gets deposed, and only then do we get to hear from him. We've never had a chance to meet him or talk with him or even find out what his thinking is. I think common sense dictates we've got a contested docket. Let's hire an expert from Dominion. Maybe it'll be of some help and value. I hope so. But when the parties reach a settlement agreement, and we always encourage them to do so, in the interest of promoting justice and goodwill and, bringing commission a product that we can review and approve, why put them through this burden of having to deal with an expert, not knowing what the outcome will be? It's going to handicap our schedule. Mark my word, we will not meet our statutory deadline if we do this. There's just absolutely no way we can do it, given the limited amount of time we've got left in our calendar this year. Thank you.
Chair, I'm sorry. Chairman Williams.
Yes, sir.
Uh, may I follow up with Commissioner Irvin?
Absolutely.
So, Commissioner Irvin, I generally agree with what you're saying, so I want to, I guess, shape the nation in a form that meets your needs and what I think I'm saying, but apparently not doing well. Are you, first of all, the consultant that you put in your motion, Power Advisory, who I believe is an excellent firm? Are you married to that particular consultant, or will you accept a substitute for that?
I would welcome fellow commissioners' input on who should be the expert in the Dominion avoided cost docket. The only reason I put their name in is they've been there before, and I thought that the fact that they are familiar with Act 62 and our procedures and processes and rules, that perhaps they hit the ground running. I don't know about the others. I hope they can, but I'm open to suggestions. Maybe we should authorize our clerk to interview two or more, and she can make a determination and a recommendation on what's best after she's talked with them, because we can't talk with them, and they can't talk with us, and she can't talk with them about the facts of the case except to negotiate an engagement agreement. So, if you want to add another name, we give her either or. Let her get on the phone and see make sure they're available, because
Understand.
they understand our time frame.
Well, first things first, my preference was actually if we could either include or use London International. Relative to whether we hire the consultant prior to the hearing for Duke Energy, my first preference was that we simply use one for Dominion as you have in your motion, and determine whether one is needed for the Duke companies after we decide whether we accept or deny the stipulation. That's my preference. So I prefer fewer words rather than more words, but yes, it's your motion.
Yes, sir. As I understand your comment, I would accept a friendly amendment, striking Power Advisory and inserting London Economics. If that's the will of the commission, I have no problem with London Economics. No one's objected to them, and they're certainly well qualified. So if that's the preference of the commission, I accept the friendly amendment.
Well, I believe that all four were well qualified, and I believe Power Advisory is also either or. I believe we could not go wrong, but I think a fresh perspective may be beneficial, but that's just an opinion of mine. That's all I had.
All right. Is there anything else before we vote, Vice Chair Belzer? I see your microphone is on.
Mr. Chairman, I was concerned with Power Advisory, but that's now been taken care of. I think that Power Advisory did a good job for us the last time. They were certainly got the reports done within the time frame. My concern this time was merely that with the final conflicts check letter that was filed on this past Friday, they indicated that they had ongoing projects with two members of SECIBA. And that is the only concern that I had with that one. So while London Economics International indicated that they had some prior work that they had done for affiliates of parties or parties or clients who were members of our associations. Those were all done in the past, and they did not indicate any kind of current involvement with anyone involved. I also note that the parties were given the opportunity to comment on any of the consultants that we interviewed. Um, Duke, the Duke companies is the only party that I have seen comments on any of these consultants that we interviewed. I would like to note that I don't believe that hiring a consultant would throw our calendar or schedule off. I believe these hearings were set for August so that that October would be available if necessary to have the consultant come in for a hearing to respond to questions from any of the parties or the commissioners after receiving their report and responding and conducting discovery that any of the parties may wish to do. So I think that the schedule as set was planned with that in mind, and I do not think that hiring a consultant for either or both of these dockets is going to throw off the calendar, the schedule, and I don't think that should be determinative of how someone may vote on this. But I am in favor of a consultant for all three dockets. Thank you, Mr. Chairman.
Commissioner Williams.
Thank you, Chairman Williams. As one of the four new commissioners who has not heard an avoided cost case, I'm supportive of hiring an expert in both cases. I think that while stipulations have great value, they also have the ability to blind us to potential questions that should be delved into, and the experts will offer us that in these three cases. I do think that because of the stipulation, there could be opportunities to be the best stewards of the public dollars that have been allocated for this, and will support staff in creating contracts that allow us to look at phases of the work going forward. I can go into more detail, but I don't think that's the time right now. But thank you, Mr. Chairman.
All right. Is there any more discussion?
Mr. Chairman, this is Commissioner Thomas.
Yes, sir. Go right ahead.
Thank you. I started out a long time ago, months ago, thinking that it would be wise to hire the independent consultants. And part of my reason for thinking that was I wrongly believed that we would be able to have some communications with those consultants, or at least our staff would. And unlike a lot of you attorneys that understand the law, and I don't, I just think there's benefit to be gained from being able to communicate with the consultants, and we cannot. So I'm less inclined to want to hire consultants, and I am okay with hiring a consultant in the Dominion case and not in the Duke case. And perhaps if we went through one with a consultant and one without, we could learn a little bit from that experience. We could have the comparison. And for moving forward, we might then next time make a totally different decision. I don't think there's anything wrong with doing a consultant in one and not in the other. So that's basically just my thoughts. There's been a lot of really, really good conversation here and a lot of good points brought out. But that's where I stand. Thank you.
All right, commissioners, if there are no more comments, questions, or concerns, you've heard Commissioner Irvin's motion. We're going to vote starting with District 1. Commissioner Williams.
No.
Vice Chair Belzer.
I vote no.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
No.
Chairman Williams votes no. The motion fails. Vice Chair Belzer, I'd like to pass the gavel to you.
Yes, sir, Mr. Chairman.
I have a motion, fellow commissioners. I move that the commission retain the services of London Economics International to serve as a third-party expert in all three avoided cost dockets. My computer has died here. Vice Chair Belzer, could you read those docket numbers for me, please?
The docket numbers are 2021-88-E, which involves Dominion Energy South Carolina, docket 2021-89E, which involves Duke Energy Carolinas LLC, and docket number 2021-90E, which involves Duke Energy Progress LLC.
Thank you, ma'am. I further move that staff under leadership, well, not even staff, our executive director, Jocelyn Boyd, would work with the commission to form terms of the contract to ensure that no more work than necessary is performed in review of the settlement offered by the Duke companies and to ensure that the schedule is maintained, that the commission meets their statutory deadline. That's my motion.
Thank you, Mr. Chairman. Commissioners, you've heard the motion of Chairman Williams. Are there any questions or any discussion?
Madam Vice Chair.
Commissioner Powers?
Mr. Chairman, would you entertain considering giving Ms. Boyd the right to put some sort of timeline on the expert? Certainly, they are experts to stay with our schedule, and if they agree to a contract, then I think we can limit their time as far as giving us a report or doing the necessary work. They all indicated in the interviews that they're ready to roll. If they're ready to roll, I think there needs to be some limitation on when they finish with their work.
Friendly amendment, gladly accepted. What I will do, Commissioner Powers, since our executive director is in the room with her microphone on, if she has any comments about the schedule, any concerns, or anything she'd like to bring to the commission, she is here and available to do that at this time regarding this subject.
Yeah, Mr. Chairman, just thinking, all the parties I'm sure will want to know a schedule, and maybe the issue maybe we'll have to place this matter back on the agenda next week, because we're going to need to know when the commission wants the consultant's report due, any discovery deadlines, the follow-up hearing. If we make it that far, I think the parties, in addition to the consultant, will need to know that information. So I foresee this issue being placed on the agenda again, and the consultant and the parties will just have to comply with the commission's schedule.
Okay.
Because that's not something I think I need to
address at this time?
No, sir.
Understood. Okay, so Commissioner Powers, I will accept your friendly amendment. The specifics of that schedule will be discussed. Now, Executive Director Boyd, you think the commission, you think you will be prepared to discuss that schedule or present a recommendation to the commission regarding the schedule next week?
Yes, sir. So, yes, and I can ask for clarification, I think, once you all vote on this motion, but the schedule that we set, of course, will have to be public, because we're not going to be able to speak to the consultant. Any contractual discussions, I think, will have to take place between Matthew Hall and Director Hall, and then he will consult with the contractor. And then after that, all communication will have to be public.
Understood.
Yeah.
All right. Any more questions, concerns regarding? Wait a
Mr.
minute.
Chair-
What am I doing?
Mr. Chairman.
I'm sorry. I'm sorry.
Mr.
Chair
Chairman, the
Belzer.
chairman accepts the friendly amendment of Commissioner Powers. Commissioner Powers, do you have anything else?
No, ma'am, I would not, other than I guess if I need to request that, it be put on next week's docket.
I think Executive Director Boyd is nodding her head, so I think she already has that.
Yes, ma'am.
So,
Thank you, ma'am.
any other commissioners with discussion or questions regarding the motion?
Madam Chair, I have a question.
Commissioner Irvin.
Thank you. What are our plans for next Monday's hearing? Are the parties, are they going to be asked to explain the terms of the settlement agreement to the commission and answer our questions? Or tell us, I'm just thinking in fairness to the parties and their attorneys, we need to let them know what our expectations are.
As far as I know, we will proceed with the hearing as they've outlined in the settlement. Now, I don't know anything different,
So
but I will defer to the chair.
this will be a settlement hearing, is that correct?
We are going forward with the hearing, and they have proposed a settlement and settlement testimony, and so we will go forward with that. Now, if they choose not to put up any, and I think they will, depending on the terms of the settlement. This is just me, Mr. Chairman. Do you need to respond to this question?
I can't, but
since this is a hearing for next week, I mean, we will proceed with what's presented. But when they
So is it fair to say the parties have the option of not participating? Is that correct?
which parties?
Well,
I mean, nothing.
JDS said they don't need to participate, that they signed off on it.
JDA.
Yes, ma'am.
That's up to them if they choose not to attend. I don't think the commission has entered any order or told them to excuse any witnesses. I don't think anybody's been asked. I don't think they've even asked to excuse any of their witnesses. They've just said that this is what they're gonna present. This is what they've agreed to present. But anytime parties do a settlement and if they limit what they're gonna present, that's up to them, and that's at their risk if they don't put anything else up.
Okay, thank you.
Mr. Chairman, you want to add anything?
I think you said it. You said it all.
Okay.
Nothing to add.
Anything else related to the motion that is pending?
Vice Chair Belzer?
Commissioner Williams.
Thank you. Given the importance of time, is it possible to hold a commission hearing and establish that schedule at a specially called meeting? Would it be advantageous to do it since we're meeting anyway?
You mean prior to Monday, Commissioner Williams?
Well, prior to Wednesday,
Prior to
especially.
Wednesday? Yeah, I guess the chair would have to determine what time, since the hearing will begin Monday. So I just need to know what time to schedule the special meeting, and yes, ma'am. We can do that prior to Wednesday. Yes, ma'am.
I bring that up not as a amendment to the motion, but just as another option beyond waiting until Wednesday of next week. Thank you.
Any questions or discussion related to the pending motion? Hearing none, we will proceed to a vote. And I usually go by who makes the motion. Start with them. Chairman Williams.
Aye.
Commissioner Powers.
Aye.
Commissioner Williams.
Aye.
Let's see, who's three? Commissioner Caston.
Vice Chair Belcher, I respectfully vote no.
Thank you. Commissioner Irvin.
No.
Commissioner Thomas.
No.
And I vote aye. I think that's 4-3, isn't it? Did I get everybody? 1, 2, 3. Yes, thank you. I think the motion passes. Chairman Williams, I return the gavel to you at this point.
Thank you, Vice Chair Belzer. Attorney Butler, please call the next agenda item.
Yes, sir, Mr. Chairman. With that item, the utilities agenda is complete, and we're prepared to move on to the motor carrier agenda. Item number 1 is the application of MAPOP Transportation Services for a Class C non-emergency certificate.
Is there a motion?
Chairman Williams.
Commissioner Caston.
I'm getting a little feedback. Let me try to fix that. Can you hear me okay?
Yes, sir.
Can you hear me okay, Chairman Williams?
Yes, sir.
Okay. Technical problem on my end. I move that the commission approve the application of Mapro Transportation Services LLC for a Class C non-emergency certificate. I so move.
Hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 2 on the motor carriers agenda is docket number 2021-137T. Staff presents for commission consideration Mark I Moving and Storage Inc.'s application to amend its tariff.
Is there a motion?
Chairman Williams.
Commissioner Caston.
I move that the commission approve the application of Mark I Moving and Storage Incorporated to amend its tariff. I further move that the commission reject the 5-day time limitation after remove listed in the bill of lading for reporting damaged household goods. 30 days at a minimum is a more reasonable time frame and should be approved instead. In addition, I move that this time frame be further considered in the commission's ongoing review of transportation regulations. I so move.
Hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 3 is docket number 2021-60T. We have a request of Morgan Overstreet Trap, DBA Embracing Our Seniors, for an additional extension of time until December 31st, 2021 to comply with commission rules and regulations.
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you. I move that the commission grant the request of Morgan Overstreet Trap, doing business as Embracing Our Seniors, for an additional extension of time until December 31st, 2021 to comply with commission rules and regulations. Although the company has been granted 2 prior extensions for this purpose, I would point out that the extensions were granted were for a very limited amount of time. In fact, they were for less than a month in both cases. I so move.
Hearing Commissioner Williams' motion, is there any discussion? Hearing none, we'll vote starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, that completes the motor carriers agenda, and indeed the agenda is before the commission today.
Thank you, Attorney Butler. We will see you all next week for the weekly commission business meeting next Wednesday, August the 2nd at 11 a.m. I'm sorry, August the 4th at 11 a.m. Thank you.
Mr. Chairman, do we have a motion, do we have a hearing this afternoon?
We have oral arguments. Yes, sir. Oral arguments
2
at 2 o'clock.
All right, thank you.
Yes, sir. We're adjourned.